One of the main questions we often get in probate is, how long does this take? The short answer is it's going to take at least 6 months because the court requires a probate to stay open that long. The longer answer is it usually takes between 6 months and 2 years. The way the firm helps personal representative and administrators in a probate situation is really to help them understand the game. Most of us don't go through it very often. Usually the first time is when one of our parents dies. When that happens, most of us have no idea how to transfer those assets to the next generation or even to the surviving spouse. And so what we do is kind of help them understand how the process works. In the case of probate, it's really a 6-step process. And the first part is getting appointed by the court. What the court does is issue letters of administration. Those letters, as they're often referred to, basically act as the power of attorney for the deceased. And so you speak with the deceased's voice, you can make decisions for the deceased, you can talk to the bank, the hospital, and do all those things you would imagine a power of attorney could do for a living person. It's also worth noting that power of attorney documents are void at the moment of death. And so the only person who can speak for the deceased is that person who is appointed by the court as personal representative. The next part of any type of probate is simply sending out notices. The first thing we help a family member do is send out notices to all the legal heirs. In the cases of a will, that is going to be the designated beneficiaries of the will. If you happen to die intestate in Montana, that would be those legal heirs, usually determined by blood, that would inherit next. That is the surviving spouse, the children, then the parents, etc. And so once we have determined who the heirs are, we would send notice to them to let them know, legally speaking, that their loved one is dead. The next thing you have to do is run notice in the newspaper. It seems kind of archaic, and it probably is, but in many legal proceedings, you must run notice in a newspaper for 3 consecutive weeks. And that is still true today in a probate situation. That newspaper has to be a newspaper of what they call general circulation in the community. And unfortunately, those newspapers are getting rarer and rarer. And so the cost of that aspect of probate is only getting more expensive. I can see in the future that potentially may change. There could come a day when we use the internet better for that type of notice to the world, basically. But as it stands, it is still the newspaper. By far the most work we do and the greatest assistance that we offer the personal representative is helping them organize what they refer to as the inventory. And this is a list of assets that the person owned at the time of their death. This can be real estate, cars, boats, four-wheelers, or simply the cash in the bank. We have to make a detailed account, again, an inventory of that asset list, and we report that to the court. That also is sent to all the heirs so that they know what was owned at the time of death. The next step is to do what they refer to as an accounting. This is basically telling the court what happened to those assets. In many cases, the will say specifically that one heir gets one piece of real property, or that their 3 children each get 1/3, 1/3, 1/3 interest in the real property. That said, it is very rare that you would want to own 1/3 of real property. And so in those type of designations, the personal representative almost always sells the asset and simply divides the money 1/3, 1/3, 1/3. And so that's what you're reporting to the court in the accounting, is what happened to the asset. If it did sell, how much did it sell for? You definitely have to report tax liability if there is any. And finally, you have to file an affidavit with the court to close the estate. It's important to remember that even after you close the estate with the court, a personal representative is still appointed for 1 year after that. This allows the personal representative to finish up any remaining business, usually with the bank, that needs to get done. And so it's not a quick process, but part of what we do as a firm is help you manage that process systematically so it doesn't become overwhelming. And also to make sure you get the process done, because if you forget to do something, it's not uncommon for another heir to contest the proceeding, and that only makes it more expensive and more stressful.